start it, right? Live.
Yeah. We'll start it. As soon as the guest join, we will start it.
Okay.
No, it is not live streaming for me.
Wait, it's coming, it's coming, it's coming. Yeah, it's on live.
It's live, huh?
Yeah.
Yes.
Our speaker and guest name is Gopika Nambiar.
She'll be joining in 5 minutes, I think.
Okay, done.
I'm also co-host, right?
Yes, you are co-host.
Okay.
Gopika is coming.
Good evening. Good evening, ma'am.
Good evening. Hi.
Good evening. Hi. How are you?
Good.
How are you, ma'am?
Fine. How are you?
I am fine. I'm doing well. Thanks for joining. With us.
No
Please check
problem.
your video and audio, and then PPT is ready.
Yeah. My voice is, very audible, right?
Yeah, your voice is audible.
I'm
Right?
audible, right?
Yeah, you're audible.
Just 1 second. I just take my earphones. Just a second.
Yeah.
Yes, I'm ready.
Yes. So good evening to everyone. So today we are very happy. My Castrol Excelu Foundation is very happy to present the national webinar on acing the moot court competitions. So today we are very much happy to host one of the young and dynamic, versatile, and such a brilliant advocate, my senior, and one of my inspiring mentor, and a great guide, and the constant motivator in my life, Ms. Gopika Nambiar, advocate, High Court of Madras. So, the reason for launching this national webinar on acing the moot court competitions is in the life of the budding lawyers, the law students in the law schools across the nation, they have to take part in a lot of programs, debates, competitions, seminars, national conference, international conference, moot court competitions, and all the opportunities given to them. They must have the caliber, the potential power, and the talent to grab those opportunities and excel. That is very, very important. In the law school, when I was a student of SOIL, when Miss Gopika ma'am is a student of SOIL, she used to grab all the opportunities given to her by the institution, and she used to take part in a lot of national and international moot court competitions. And she used to ace those competitions, and she used to bring laurels to the institution. So in such a way, we need to expose ourselves into a lot of opportunities, and we have to develop our skills, and we have to learn every day. This is very, very important for a law student, because law is not only a learning area. We have to gain an experience, we have to expose, we have to apply. That is very, very important in the legal profession. This is what I learned. So many students may get an opportunity to take part in moot court competition. Some may not have any idea about the moot court competition. Some may have good opportunities before them. Some may not have a good opportunities before them. Some may have an already and good exposure through her senior or through her parents. Some may get some kind of an exposure about these moot court competitions. They may have some awareness. Some may they don't have any awareness about the moot court competitions. And some students, they don't know the procedure. What are the steps we have to equip ourselves to take part in the moot court competitions? How the moot court competitions works? How we can win or ace the moot court competitions? How we can train ourselves as a best mooter, and how we can become a best mooter, where these opportunities of moot court competitions are available, how we will come to know about the moot court competitions. Many students, they don't have this kind of an idea and awareness. So moot court competitions, according to me, it is very, very important in the law student's life to take part and gain an exposure, because the moot court will improvise your research skills, your communicative skills, and then your speaking skills, and then your ability to become a very talented student in your law school days. And this will equip you in many ways: your speaking skills, your communication skills, and then your research skills, and then your capability to face everything in a bold manner. And the challenges, this is very, very important for a law student. You should not have any fear. You must be confident to be the public speaking skills. That is very important. So what I feel is this moot court shapes the student in such a way the students can get all this exposure, and they'll be able to face the legal profession after pursuing their legal education. So that's the reason I organized this national webinar on acing the moot court competitions through my Castrol Excelu Foundation, because many students, they don't have any awareness about the moot court competition. They don't have any idea about the moot court competition. So through this national webinar, Ms. Gopika Nambiar will address on various areas how this moot court competitions works, what are the steps, how we have to prepare for the moot court competitions, and where these opportunities for the moot court competitions are available, and what is memorandum, the memo, the moot memo, how the moot memo structure and then its model, how we have to draft the moot court competitions memo, and then how we have to face the moot court competitions, what are the skills and what are the talents, and then what are the way you can ace and win this moot court competitions. So Ms. Gopika Nambiar will brief and explain us all these aspects. And she has a very, very good profile in this moot court, and then overall in her academic uh, time during the legal education days in the School of Excellence in Law. Ms. Gopika Nambiar has won many national moot court competitions, and she has been an 8-time Best Advocate Award in the national moot court competitions. And then she has also took part in many national moot court competitions in the national law schools in India across the nation. And she has also listed as the top 5 best speaker in the National Youth Parliament organized by the Ministry of Home Affairs. She is a best orator, a best speaker, a best law student of the School of Excellence in Law. And even after she left the School of Excellence in Law, for many university moot court competitions, orientation programs, she used to come and address the institution students, and she used to motivate them to take part in the moot court competitions. And she has also went to many institutions as a chief guest, as the judge for the moot court competition. And even this year, I have organized a national virtual Indian Parliament. In that, she was deserved, and then she won the best national level best parliamentarian award from Honorable Justice AHMD Nawaz, President of the Court of Appeal Sri Lanka, and Dr. Raghavan Sitaraman, CEO of Doha Bank, Doha Kota, and Mr. Prabhakaran, Advocate Supreme Court of India, conferred her and selected her as the best speaker of the National Virtual Indian Parliament organized by my Castrol Exedu Foundation. And she was the best parliamentarian across the nation. More than 500 participants they participated, but she won the competitions as the best parliamentarian. So she is the best researcher, and she used to write a lot of articles to various newspapers and publications like Bar and Bench, Indian Express, Hindu, and then she has a very good, such a talented young advocate, and she is always focused on her work, and she used to express her views on various issues. Even during the time of pandemic also, she has wrote a lot of articles on the healthcare and then public healthcare system, and she always an inspiration to the young generation and the young advocates. And personally to me, she is a great inspiration during my college days. So when I think about this national webinar and acing the moot court competitions, I immediately thought this Gopika Nambiar, because she will do a great job in this national webinar by briefing various perspectives on the moot court and the moot court competitions, the way it works. So now I welcome Ms. Gopika Nambiar to this national webinar on acing the moot court competitions. So now you can begin, ma'am.
Yeah.
I take immense pleasure to welcome you, and we are very happy to host you today. Thank you for accepting our invitation in the midst of your busy schedule. Thank you so much.
Thank you very much. First of all, Abhishek, for the very generous introduction. It was very, very generous of you. I don't know how much I deserve, but thank you very much. And a big thank you to your foundation, Castrol Edu Foundation, as well. And it's very commendable that you're conducting webinars like these, which would help law students. And yes, so the topic that you have given me on to speak is on acing moot court competitions, how to ace moot court competitions. But I would first like to say that to participate in a moot court competition itself is very important, and that itself gives you so many benefits. So I would say that winning is secondary. By participating in a moot court competition, you are preparing yourself for your future career, your future career before the court of law, where you have to argue cases. So in moot court competitions, a moot proposition, which is like a case law, is given to you, and you have to prepare arguments for both sides, and you present it before advocates, and you also get the rare opportunity to present cases before sitting judges of high court, before sitting judges of Supreme Court, even before you pass out from law school. That is such an incredible opportunity which only moot court competitions give. And imagine what a confidence booster it would be for a budding law student to be able to argue before a Supreme Court judge in the final round of a moot court competition, much before he even passes out of law school. So that is a huge takeaway. And apart from that, you learn how to research, You learn to think on your feet, because in moot court competitions, judges keep throwing on a volley of questions to you. You learn how to, give logical answers. You learn how to research. You learn how to speak without being afraid, and you learn teamwork. So those are very, very important takeaways which you get just by participating in many moot court competitions. And and in fact, I would like to say that winning a moot court competition uh, comes it's not something that comes very easily. It's like a difficult exercise in the gym. The first time you try it, it's going to be really difficult, but as you keep doing it, it becomes easy and you master it. So we must not go out there and expect that in the first moot itself we're going to win that moot. But we must take it as a learning experience, a gradual process, and then do our best at it. So yes, I will I will share my experience, and I will tell you what are the things that I learned from my 5 years of mooting, which I hope will be, I'm sorry, yeah, which I hope will be useful to all of you. So firstly, the first step is, of course, to choose the moot. We all know that in today's time, every law student knows that, in Law Octopus is a website wherein different moots are notified, national and international moots. And now I understand that every law college also has a moot court association where they notify different moots, so that, students can choose which moots they want to. They'll have internal challengers and then they will participate. So, sorry. Yeah, so choosing the moot is a very, very important step. So if you ask me, when I started mooting in the first year of college, so when I started, I always made sure that I start small. I don't start with a moot that is if I would say, is very big in the hierarchy of moots. For example, I would not do my first moot at a national law school. I would not do my first moot at in a subject which is a little complicated. For example, securities law. I would choose not to do that first, because I believe that you have to start small. I would recommend starting a moot court competition which has a simple problem, maybe a simple constitutional law problem. Maybe you can start with a state moot, so that gradually you progress. First moot, securities law, you will get overwhelmed by it. So start gradually is something which I recommend. And the second and the most important step is to choose your team. Now, we all know that moot court competition is a teamwork. It's a team of 3 where you have 2 speakers and a researcher. Now, each and every person's role in that team is extremely important. Even if you're the researcher, you have a huge role. It does not mean that the researcher is not speaking. So, you can have anybody as, the researcher. That's absolutely not the case. The researcher has a lot of work to do. So what I have seen is that always people, when they select the moot team, they tend to go for people who are the best at it. In the sense that people who are best at speaking, who have a lot of legal knowledge, etc. That is very important, definitely. But according to me, one factor which is even more important is to select teammates who are willing to work hard. Because moot court competition is not a cakewalk. You have to give a lot of time in researching and preparing the memorial, preparing your arguments, etc. When I used to participate in moot court competitions, we used to sit at 9:30 in the morning, and we of course took a few breaks, but then that preparation would go on till 9 in the night. So that much amount of time, you have to spend on maybe a non-working day in your free time. So if all the 3 members do not put in that hard work, then you can forget about winning a moot. Therefore, choosing a teammate who is willing to work hard is extremely important. Right. Now, the third step, of course, is to prepare a memo, or to prepare, in other words, the written arguments. Now, of course, I'm going to only give you an outline of everything, because, of course, we have only 1 hour. And if I talk about all the nitty-gritties, then I'm going to take the whole day. So when it comes to memo preparation, the first and foremost thing that you have to do is to read the problem, to read the mood problem multiple times, because every time you read a line in a mood problem, it gives you a different meaning, or some idea strikes you. So it's extremely important to keep reading the mood problem multiple times. Every day that we used to sit for preparation of memo, our day would start by reading the problem every day. So that is a very important thing which every one of us should inculcate. And we all know that every mood problem is based on a spoof case. It's based on a case that actually happened in some court in India. Okay. Sometimes it's a combination of 2 or 3 spoof cases. So always the first thing that needs to be done is to identify what are the spoof cases that are involved in this mood problem. That you of course get by resorting to our dear friend, which is Google. Now, in fact, searching on Google is an art which which you learn by practice. Because if you're searching any proposition on Google, for example, say you want a case law on the proposition that right not to be the right to be considered for promotion is a fundamental right. So when you're going to search that proposition in Google, it's always very important to type it out in the most minimum number of words to get the right result. Because I see people, whenever they want something on when they want some case law on Google, when they type out the proposition so in so many words that you end up not getting the right result. So you always have to type whatever you want in Google very concisely. This might seem like a very silly thing, but it actually goes a long way in finding out what you want to in doing mood research. Now, of course, with live law, bar and bench, research has become much more easier. You don't really have to depend all the time on Manupatra and SEC, because everybody cannot afford an SEC or a Manupatra subscription. And I have also noticed that searching on Google is much more easier than searching on SEC and Manupatra. So what I do is, if I have to search a judgment, I search it on Google, get the citation, get the judgment on SEC, and read the judgment on SEC. Because one thing is there, reading the judgment on Indian Qanun, I mean, all of us know that we all generally read on Indian Qanun, is sometimes not advisable, because there tends to be some kind of, small mistakes that Indian Qanun does, though it's extremely useful. But sometimes there can be some mistakes. So it's always better to read it when it is reported on SEC or in Manupatra. So I get the citation and then read it on SEC and Manupatra. That is the method that I employed. And then whatever arguments you have to make sure that it's supported by precedents or supported by case laws. That's extremely important. And then yes, and then when you read a judgment, always make sure that you don't read just the head note, because head note is provided by the law database that is reporting the judgment. That is not exactly the judgment. So you always have to read the full judgment and understand and see if it applies to your case as well. The reason I'm again stressing so much on judgments is because precedents are extremely important, both in courts and in moot courts. Okay. Then, yes, the second place where you can search, where you can research for case laws and for innovative arguments is commentaries. Okay. Every subject has its own commentary. For example, if you're doing a moot on constitutional law, you must refer to Durgadas Basu's commentary, because it's a very exhaustive, commentary. I mean, I'm not just referring to D.D. Basu, but any commentary for that matter will be exhaustive when it comes to the concepts. Because in Google, you can always search to find out the latest position. But Google is not like an open book which can tell you all the concepts. So if you are, for example, doing a moot on Article 19, you have to take the commentary, read the history of Article 19, read the case laws that have been decided, and then go in, because there are also if you read commentaries, there are also doctrines and there are also philosophies of law and concepts that are explained. For example, the doctrine of political question. That's if you don't know about that doctrine, it's not, I mean, you will not know that you have to search for it in Google when you get that problem, right? But if you go to a commentary under Article 32, that doctrine of political question will be given. So that is how commentaries become very useful when it comes to research and in getting in framing innovative arguments, right? So then yes, that is it about research. And before you go into the memo, two most important things is, one is you have to frame the issues that are to be decided in the moot court. Framing an issue, of course, some moot court competitions give the issues by themselves, some don't give. But when you read a moot proposition, invariably you will understand that what the petitioner side and the respondent side does not agree on forms the basis of the issue. Okay. And generally, the first issue in any moot problem would be the maintainability. But maintainability, of course, is not always an issue. Sometimes maintainability is given that it is maintainable. But otherwise, the first issue generally tends to be on maintainability. And the second most important aspect is to decide what is your prayer, what you want from the court. So these two aspects, deciding the issues and deciding the prayer, is something you should never, ever go wrong with. Because once you give the correct issues and give the correct prayer, there are two columns for that in in a memorial correction or in the oral rounds. So if you get that wrong, then you tend to lose marks just for that. So it's very important to get the issues and the relief that you want correct in any moot court competition. Now I'll just show you a sample memorial. We'll just quickly go through a memorial. So Abhishek, could you just share that?
I request Jai, please share that PDF of the memo. Ajay, can you share it?
Yeah. So as you can see, that is the first page of any moot court memorial, wherein you have, of course, it first says before the Honorable Supreme Court of so and so, which is the forum. Then you have the case number. Then we type out the parties to the moot. And in this case, of course, there were two writ petitions. That's why you have two cause titles. So it's called the cause title, basically. Petitioner versus respondent. That's called the cause title. Then you have the table of contents. You can come down. You can come down.
Scroll down.
Yeah, you can scroll down. Sorry. You can come to, I'll tell you which page. Yeah, you can come to page 3. Page 3, which has index of authorities. Yeah. So this is the index of authorities, where we give an index as to what all cases that we've referred to. First we've written Indian cases. What are the case laws in India, which we've referred to. Then the next page, please. Then we have a list of the foreign cases that we've referred to. Then down you will get further down, please. You will get, whatever declarations we refer to, what is the books we refer to. Right. And then the next page, please. Yes. So this is the statement of jurisdiction, wherein, you say that this particular case is within the jurisdiction of this court. So that has to be very small. So yeah, that's very, very simple. I don't think there's anything to explain in that. So yes, next page is important. The next page, please. Yeah, statement of facts. So there are, different teams frame the statement of facts in different ways. Okay. The first important thing that you have to take care while framing the statement of facts is that it should be as it is. You cannot play with the facts while drafting a moot court memorial. It should be neutral and it should be as it is. And you will see that I have we've done this. We've always had this style of giving side headings for facts, especially when it's when the mood problem runs to many pages. It's very easier when you give the side headings. Please come down. Yeah. So you can come further down. You will see that there are side headings, and then we've given the facts to denote different parts of the mood problem. So that is something that you can resort to, to get some bonus marks. Then you can come to the next page, please. Next page, next page. Statement of issues. Okay. So these are the issues involved in the mood problem. It always starts with whether there. Okay. And yeah, that's self-explanatory. And then the next one. Next page, please. This is the summary of arguments. So please note that summary of arguments should be a summary. I mean, you don't have to put all your arguments here because it's just supposed to be a concise, form of your main arguments. Okay. So you can see that, we've put it very small and we've made it very concise. Please scroll down. Yeah, scroll down. Next page. Next page. Yeah, arguments, right? So, right. So this is the first issue, and you will see that if you see the fourth line, we say it's basically about a transfer petition. So it says such a transfer petition is sustainable in law on account of, we divide it into two sub issues. So the first issue we divide into two sub issues, and we say it is sustainable on account of A, right of access to justice, and B, principle of rule of law. So we divide the issue further into two sub issues to make it, to give it more clarity. And then we are here, this is of course a constitutional law problem. So here we are talking about a right. So you will see that first we explain the nature of that right, and we explain the history of that right. Please come down. We talk about how, it is a part of, it is a human right, it is a fundamental right and all. Okay. So we first give that, and then we give case laws in support of the recognition of that right. You can see that in paragraph 8. Yes, please come down. And so all of that is about the right. And then we talk about another principle of, rule of law. Okay. And see, basically here we are talking only about the right, and therefore we've given a long explanation about the right, because this is the kind, that is one kind of a mood problem. But generally, in any mood problem, when you draft the issues, it should always be, you first explain whatever principle you want to explain, and then the next paragraph should be your correlation with the facts. Why are you saying this principle? How is it relevant to the facts of your case? Okay. So that is the model that you have to follow, because it's very, very important to write what is the correlation with your facts. Actually, in this problem, that correlation comes later, because this is more on a legal side. But most cases, you will first have to write about the principle or the concept about the right, and then about what is your correlation with the facts. Okay. And see, one more thing in a moot court problem is, okay, first I will show you one more thing, and then I will explain that. You can come down now. You can come to the last page, please. You will see basically in our moot memorial that we've tried to give a lot of sub issues, because if you just continue putting in on your issue like a story, the memorial is not going to look very attractive. So you put in lots of side headings, you put in lots of sub issues, you dissect the issues into different legal arguments, and then put it. Please come to the last page of the document. Yeah, prayer. So this is how the prayer should look like, because we have two cases in this thing. We have two separate prayers, otherwise it will just be one. So therefore, in the lights of issues, raise arguments at once. That is a standard format. We say, I love the transfer petition and hold. So basically here it's a writ of declaration, and Yeah, so it's basically a writ of declaration here. So it's very, very important to know what is the relief that you seek for. And it's very important not to put unnecessary things in the relief. For example, some relief which you actually can't get, if you put that also in, you tend to get your marks reduced. So therefore, you need to know what to ask for. Okay. So you can stop the screen sharing. Thank you. You can take off the screen sharing. Yeah, thank you. Okay. So yes, one very important thing that you have to keep in mind while drafting a memo is, of course, whatever issues you're going to raise and whatever arguments you're going to have, you have to put it in the memo. But one, the memo has its own page limit. Okay. So your memo cannot be like a commentary which keeps going on and on. And second, your little X factor points, you can not put it in the memo. Okay. Because if you give away everything, then you're obviously there is something called exchange of memorials that happens the day prior to the rounds. So if you put everything, then the opponent is going to know every aspect of the argument which you are going to say. So each and every line or each and every detail of your argument is not necessary, which is why what the usual tactic which I follow is I put my arguments on law, but the correlation with facts I put it, but I put it very concisely. I do not put it in minute detail. One. And two, don't see, for example, if you are for the petitioner, you will of course anticipate that. I mean, you're obviously preparing the memorial for respondents as well for the other round. So you would have come up with some innovative arguments when you researched for the respondent. Okay. Now, when you are preparing the memorial for the petitioner, you try to say why that point which you researched for the respondent is not applicable in the petitioner's memorial. So indirectly, you give away a point to your other side. You get it? For example, if you're saying that the doctrine of political question, you anticipate that the respondent will raise the doctrine of political question. You think they will. And you put it in your memo saying that doctrine of political question is not applicable here. So you're giving away, you are giving away a point to your respondent, because the previous day when your respondent reads the memorial, he's like, oh, okay, there's something called a doctrine of political question, right? So that is an unnecessary thing which you do. You do not have to do that. And you can you don't have to resort to giving away your points. So those kinds of things you can avoid. That is being a little more clever, and that will come with practice. Okay. And yeah, so those are the things that you have to keep in mind while drafting a memo. Now I go on to the other part of Moot preparation, which is preparing for oral arguments and then the oral arguments itself. Okay. So
Before coming to the
yes.
other part, a small
Yes.
question from a participant.
Okay.
Rishi has asked a question. Where
Yes.
the research process should begin and where the research process should end. This is the question.
Yeah, so I'm actually coming to that. Yeah, so
Yeah.
research process obviously begins when you decide that you go in for a moot. Okay, because you have to begin immediately, because you will have your internal selections in your college, and then you will have the moot itself, right? The memorial submissions are generally like almost a month before the moot, so you have to research. Now, the common mistake which people do is once they submit their memo, they think that the work is done. So they'll just end their research, and then only in the day prior to the oral rounds, they'll open their memo, read it, go do the moot. Now, that is a very common mistake which people do, which shouldn't be done. Okay. I would say that the real research begins after you. I won't say the real research, but I will say that it is very important to research after you submit your memo. Okay. The most important reason why that's necessary is because law keeps changing every day. Yesterday, there might not be a ruling on Section 377, but today suddenly a ruling might come up on Section 377. So if your moot problem is on that, you need to be updated. So your research should continue until the day of your moot. Okay, so that is extremely important, and you will always find that you have left out some points. Okay, so even if you've not put in some points in the memo, you can raise it during oral arguments. You can always have a separate book wherein you write down those points. So that is where the researcher's role becomes very important. So the speakers, of course, have to prepare also for their oral rounds. But the researcher can sit and research more and note down what are the points that you have missed, so that you can raise it in the moot court competition. So I hope I've answered your question.
Yes.
Yeah, okay, right. Yeah, if you have any further questions, you can always put it in the chat box. I'll complete and I'll answer it. Okay.
Yeah.
So the next important task is to split the issues among the speakers. Okay, so if there are 4 issues, then you have to split it among speaker 1 and speaker 2. So when you split issues, it's always necessary to have a balance. Okay, so if you're giving if for example there are 4 issues, 2 are tough and 2 are easy, so you balance it out by giving 1 tough issue and 1 easy issue to one speaker, 1 tough and 1 easy issue to the other speaker. Because what happens is, see, a common mistake what people make is that, for example, speaker 1 may be very good in speaking. So what people might do, give both the tough issues to that speaker and give both the easy issues to the next speaker. But what will happen if speaker 1 actually is questioned a lot and he's not able to answer the questions to the judges? Basically, what happens is that they will say, oh, speaker 1 was really bad, speaker 2 was really good. They will give more marks to a team which has more balance, right? So if you're one-sided, you can never end up winning the moot. So when you split issues, you must always split it wisely. But having said so, the toughest issue should always go to the best speaker. When I say best speaker, I don't mean a person who can do good oratory. That's not what I mean. A person who is intelligent, a person who can handle questions without losing his confidence, person who has good legal knowledge in the subject. That is what I mean. Okay. So that is how the most important step is to split the issues. Then, even if you have split the issues, it's very important for all the speakers to know each other's issue. Speaker 1 should know speaker 2's issue, speaker 2 should know speaker 1's issue. Because what happens more often than not is the judge questions speaker 1 on speaker 2's issue. Okay, as speaker 1 says, I do not know, my co-counsel is going to deal with. That is a wrong answer. Both of you should know each other's issue and the researcher should know everything. Okay, and yeah, so then whatever case laws or precedents that you are referring to, or you would obviously have referred to a lot of precedents in your memorial. So what the researcher or the speakers themselves, what they can do prior to the moot is to keep a note, write down the facts of each case law you have referred to. Because many times, the judges ask you, okay, what is the facts of that case law that you have referred to? Because we all know that precedents depending on facts, right? On a particular facts, a particular proposition of law might have been given. That will not per se apply to a different set of facts, just like that, right? So you should know the facts. So you write that down in a book so that it becomes useful for you in your rounds. Then this is also a very, very important thing, that when you draft your memorial, you would have seen, like now, for example, you saw the memorial. I screen shared now. You saw that it talks a lot about the concept of the right. For example, it was on right to access of justice. So I have quoted lots of international conventions, lots and lots of case laws wherein the right was recognized, etc. But when you argue, you obviously have limited time. So you cannot say all of this. So you have to reframe your argument. You talk about what is right of access to justice. You say which Supreme Court case law laid that down, and then you go on to your facts, right? Because if you keep talking, for example, if you keep on talking about every international convention, you're going to lose your time. So the most important points alone is the one which you're going to present in your arguments. So you have to reframe your arguments when you prepare for your orals. That is very important. Then a lot of people don't do that, because many people just tend to read off their memorial. But that is not going to fetch you marks. Then then you have to do lots of mocks. Mocks are so important. When I say mocks, I mean you can do mocks with your teammates, or you can do mocks with your seniors, you can do mocks with your professors, whoever it is. They will sit as judges. You argue before them. They will throw questions at you. So by doing that, you get the feel of a moot court competition. You know how to think on your feet. You know how to uh, when you are confronted with very difficult questions where you actually don't know anything about it, you will learn the skill of still managing to say something which makes sense. Okay, so doing lots and lots of mocks is extremely important. So just 1 second, sorry, just 1 second. Yeah, sorry. So the next aspect is to make sure that your two speakers don't say anything that is contradictory to each other. Okay, so sometimes that might happen because probably speaker 2 did not go through speaker 1's arguments, or your understanding of the case is different or something like that. So make sure there's nothing contradictory that is said, because that will show that there is a failure of team coordination. Then I come to one very important but very neglected aspect, which is court manners. So you are supposed to be extremely polite, be it in moot court or in the real court. Okay, and never interrupt the judge when he's asking you a question, or if two judges are talking, wait until they finish. Don't continue your arguments when they're talking. And one very important thing is also that see, you will see that in many rounds, judges look like they've got annoyed at you, right? So that is basically done to make you nervous, to test your ability to stay cool. It's not because they're finding fault at you or they're laughing at your point or anything like that. Because like even I've judged mood, so I make sure that I'm a little strict, that I don't appear to side with you, even though you may be correct, right? You might be correct, but I will not show or reveal it as a judge that you are correct. So when you must be confident in what you're arguing, and you must know that judges are going to be strict. They're going to shout at you. Sometimes they may even laugh at you, but that you must not let that unnerve you. Okay, because the primary thing in what you have to understand about a moot court competition is that it is obviously in one very big aspect distinct from a real court. In a real court, what is important is the strength of your case. But in a moot court, what is important is the strength of your performance, because they're not giving a judgment on your case, they're giving a judgment on your performance. So they are not going to accept the fact during the rounds, they're not going to accept the fact that you are correct. So you should not be misled by their demeanor. Okay, so that is a very, very, very important thing that will help you to be confident, that will help you to stay cool, and that will help you in general. It's something that does not that does not stay in people's minds, because when they're doing it, they suddenly become nervous seeing the judge's demeanor. Okay, then at the same time, don't overdo your court manners. For example, I sometimes see the practice of all the teammates standing up when one speaker tells the prayer. I don't think that's very necessary, and in fact I've seen some advocates get annoyed at that, because it's quite unnecessary in my opinion. And also I see sometimes counsels, whenever the judge is saying something, they have this habit of replying saying indeed. Like for example, the judge is telling you something, you say indeed, indeed, indeed. So what is that indeed, right? So that those are unnecessary things which sometimes people do in the name of court manners, but it's quite unnecessary. Then very important is to have a smile on your face. Okay, because if you appear tensed, the whole atmosphere seems tense. So you have a smile on your face. And see, things like being calm and having a smile on your face is very easy to say, but it comes with practice. You cannot you cannot I was very nervous in my first 3 moods. In fact, my first 3 moods I did not win, and the main reason for not winning was the fact that I became very, very, very nervous. Then what happened was in my third mood, one round there were 2 boys, I think, who came from National Law University Delhi. And I was completely blown away by the way they argued, because they always had the smile. They always had a smile. Even when they were posed with tough questions, they did the best they could, but with a smile. They never got nervous, and I thought it was absolutely extraordinary how they did it. And they did not have any pressure. They did not take any pressure. You must not think that yes, I have to win this round. I have to win this moot court competition. You should have the desire for it, but you should not take it as a pressure. So if you don't take it as a pressure, you will definitely be able to do well. So from the next moot, I also emulated that. I didn't take any pressure. I went with a clean and calm mind, and I just did what I had to do. And then I started winning. So that is something which, each of us will get by practice. Then, then when you narrate, the first thing that you do in the oral rounds is to narrate the facts of the case. Please be brief about it, because you're going to waste your time if you're going to be very long, very lengthy about the facts. Be neutral. Facts should always be neutral. Try and frame the facts in 5 points. I always do that. If I'm this first speaker, I frame it in 5 points and I go, so that there's no difficulty. Okay. And like I said, I cannot underestimate the importance of reading the factual matrix of the moot problem, because I can give you an example. So there was this moot about the right to protest. Okay, so I don't remember which side we were appearing in, but that moot, it was about the fact that there was no alternate place to protest, and therefore the public roads were being used for protesting. So it was on that. So then I realized that while arguing and just while looking at the fact sheet, I suddenly, after not seeing that for like, I think 3 months we had for memorial preparation, I didn't notice that particular point in the moot problem. But when I was arguing, suddenly my eyes fell on one point, that there was a huge beach in that state, and that huge beach could be used to protest, right? Because the problem was on about, I think we were for the state. We were saying that it could not be done, near in the public road. So then that line caught me. I was like, oh yes, there's a huge beach. Why can't the protest be done there? So that was just a casual line I think in the second paragraph of the moot proposition. I think none of us really read the second paragraph of the moot proposition, because we know the matter, the real issue is going to come later. But that line was proved to be so absolutely important. So that is the kind of attention to detail you have to give when you read the moot problem. Then we talk about the important, I think everybody asks me always this question as to how you convince a judge. Okay. My first answer is what I said before, that the judge is not going to appear convinced however you try. Okay. So you have to do your best, and you have to be convinced on your own points and present it. And second, see what to do if a judge is not convinced. If the judge appears to be really not convinced with your point, is to try and give an alternate argument. So whenever I work on my issues, I always try to have some alternative arguments, that shows your intelligence, that shows your knowledge, to have some kind of an alternate argument. So that is a way in which you can try and convince the judge. And secondly, you can what you say, you can try, if there's some question for which you completely do not know the answer, like that you have absolutely no idea, it's always better to say the counsel pleads ignorance. Okay, but you can't say that for every question. So that also comes by practice. Like, even if you don't know anything about something, you can always try and manage it. So that comes by practice. Those are all forensic skills. And nobody can teach you that. And if you, but generally keep this in mind, that if you have a lot of knowledge in a subject, for example, if I've done lots of constitutional law moots, so when I am confronted with a constitutional law moot problem, or when I face the oral rounds, I always find it a bit easier than some other subject, because I know the subject itself very well. So I can give some kind of an answer to any question. So if you know the concepts and if you know the subject well, it will be very useful. And please remember that if, for example, your moot proposition is about the Transfer of Property Act, please read the Bare Act completely. Even if your moot court, if your competition is only about section 34, does not mean that you have to read only section 34. Please read it completely, because you never know which section or which point you will have to take. And when you read it completely, you will, for example, note the fact that there is a non-abstain clause in some other section which influences this section, etc. So read the Bare Act completely. Whatever legislation your moot court competition is about, you should know it thoroughly. That's extremely important. Then, yes, then, never ask this question to the judge that, for example, you speak about an issue and you want to go on to your next issue. Never ask the question, if lordship is satisfied, may I move on to my next issue? Never ask that question, because the judge is always going to say, no, I'm not satisfied. Okay. So you have to, because you have a limited time, you have to answer the judge's questions. At the same time, you have to complete your arguments. Therefore, you have to, move and go ahead with your arguments. So whenever the judge tries to sidetrack you, you must find a way of answering the question and bringing him back so that you can move on, because your time is extremely important. Okay. So that, see that also again comes with practice. I cannot give you a step-by-step approach to do that. But you must keep in mind that there's something called time, and there's something and then it's very important that you bring him back. Okay. And see, sometimes it happens that the judges misunderstand the facts. Okay. So you must not get tensed by it. You must be patient and clarify that to the judge. Okay. So that such things also happen. And then, yeah. So when you have a very difficult side, for example, you're for the respondent, and respondent is, because some moot propositions happen to be slightly one-sided. I mean, they always try to get a balance, but sometimes you see that, when you're appearing for the government and when fundamental rights are in question, it's difficult. Okay. So when you're appearing for a difficult side, it's always better to anticipate what are the questions that the judges will ask. Okay. In fact, even if you're appearing for an EC side, this is a very important exercise you can do to try and anticipate. Take a notebook, write down all the questions that you think a person can ask about it. Okay. And try to get some kind of an answer to it. Okay. You can always, of course, consult your seniors and anybody and try to get some kind of an answer to it. And also you can, when you are appearing for a difficult side, this having alternate submissions will prove useful. Certain aspects, certain harmless places you can concede. For example, if you're the state and the police, in the moot problem, police has done some atrocities, there you can concede, saying that yes, there are some atrocities that take place, we will take action. Things like that. Small areas you can concede. And also you can try to be a little jovial. Also, not taking a joke out of it, but some kind of humor can also be infused. So there you show the fact that though despite the fact that you have a difficult side, you are trying, or you have given your best efforts to put up a good performance. That will impress the judge. Okay. So that is what you do when you have a difficult side. Right. And then when you're citing case laws, obviously you're going to cite case laws in your arguments. If you have like 5 case laws on a point, make sure that you cite the case law which is that of the Supreme Court. Okay. Indian Supreme Court. Other case laws only have persuasive value. Binding effect only Indian case laws have. And that too, if you're arguing if the moot court is on a problem that is before the High Court, then definitely Supreme Court. Okay. So, and also when you cite a case, please say the citation along with it. For example, Keshavananda Bharati versus State of Kerala, AIR, year, etc. So please say that along with it. Never ever, cite a case without telling the citation along with it. Okay. And yes, like I said before, always better to know the facts of the case that you cite. Then see, there must be good teamwork in the moot. Okay. Some modes allow researchers to send chits if the speaker does not know an answer. So the researcher can be vigilant. When the other side is arguing, you must note down the points so that, when it comes to rebuttal, you can answer those questions. So all of that, the researcher should play a very active role because he must try and get answers and all that, right? But he must not stand up and speak. That's the only thing. And then when one speaker is speaking, for example, speaker one is speaking, and the bench asks the speaker one a question, which the speaker one is not able to answer. Now, as speaker two, when you're going, if you know the answer to it, please answer that. Okay, you can start your arguments and you can say, Lordships had put a question to my co-speaker. I would like to answer that and say it. That will be appreciated. That's good team effort. Okay, so it does not. So when speaker one is arguing, it means that this co-speaker and the researcher should pay attention. They should not just look at their arguments. So that is the kind of team effort that should be seen. And then lastly, you have the prayer. So very important that both speakers know what is the prayer, because lots of times what happens is that the judges, just to trick you, when speaker one stands up to speak, the first thing they'll ask, okay, counsel, first tell me what is the relief you want. And speaker one is not the person who usually tells the prayer. So speaker one sometimes forgets to look at the prayer. So that is extremely bad. You have both the speakers should know the prayer properly. You should know what you're asking for. And yes, then finally comes the rebuttal. So in rebuttal, please make sure that you don't say any new points. Rebuttal is only to oppose whatever points are said by the other team. So which means, one, you have to pay attention while the other team is arguing. Second, rebuttal should be done on points which you can answer properly. It shouldn't be like you select some point which you yourself are not very, good at, and you say that, and that is wrong, and so you lose marks because of your rebuttal, right? So you must not let all such complications happen. You must think, see which is the point that you can choose to rebut, and then rebut. Okay, don't cite. It's always better not to cite case laws and all in the rebuttal. You can say that there is, this is the position of law, and say it. And no new points in the rebuttal. And of course, if you're for the respondents, you come in for the sir rebuttal, you have to precisely answer the questions raised. Okay, no other new arguments. And that's what it should be, sharp and on the point, and it should not lead you into trouble. So I think that's it. And basically the most important thing is, in a moot court competition, never ever get scared of judges' questions. Judges are there to ask you questions, and in fact, I would be very scared to face a bench which doesn't ask me questions at all, because I do not know what the judge is thinking about my arguments. Only when they ask questions, what is their response to what you have said. So please be happy, please be welcoming of questions, please don't be scared of questions. And sometimes there is no right answer to a question. Okay, there's no proper answer to every question. Sometimes judges do not know answers to the questions they ask also. Okay, so that is completely okay. Your work is only to be convincing, to give intelligent, logical and rational answers to what they're saying, not to give the right answer every time. Okay, and lastly and most importantly, please treat moot court competitions as a journey which is going to help you in your future career. So do not just go with the sole intention of winning. Try to observe your other team's arguments, try to learn from them. So all of that is going to help you in your future practice. And secondly, also there's one big benefit of mooting is that you get to travel to different places. I got to travel throughout different states in India because of mooting. So mooting is also about leisure. It's not just about work. So that's it. So I always recommend that every law student must at least try mooting for once, so that they can see if they like it, and I'm sure they'll definitely like it. So once again, thank you so much, Abhishek, for the wonderful opportunity that you gave me, and because I always like talking about moots. It's something that I'm very passionate about. So thank you very much. Thank you, and I hope I was not boring. Thank you.
you, ma'am. Ma'am, we have some questions.
Oh, yes, sorry. Yeah.
Does framing of issues on the chronology of events specified in the problem make the memo more attractive?
No. You have to frame issues based on, what, based on, okay. But when you say chronology of the moods, okay, see, one, of course, maintainability should always come first. And second, I would say the crux of the mood problem should be the second issue. Yeah. Even though that might, come in a little later. What is the crux and what is the base of the mood problem? What is the essential dispute? That should be the second issue. And then you go to the rest of the issues. There's no harm in going chronologically, but just make sure that the most important issue does not come last. Okay. So that it kind of depends on each mood problem. But yeah, the crux of your mood problem should be your second issue. Anything else?
And there is another question. How
Yes.
to aid the interview conducted by the host institutions to the researcher?
Oh, okay. Well, see, firstly, I must confess that I have never been a researcher. I've always gone as a speaker. So I've never written the researcher's test. And I don't think there's any interview in moot court competitions. I've never heard of this interview to researchers. But I mean, on a general perspective, you must know the moot problem completely. And you would have done so much of hard work in preparing your memorial, in helping your speakers. I think the researcher, if his work was done properly, it is the researcher who will have maximum knowledge on the subject, because he doesn't have the tension of having to speak, so he would have read a lot, and so he must know everything. So be confident and make sure that you know everything. That's all. But at the same time, I've never been a researcher. I have not attended the researcher's test or interview.
Thank you, ma'am. Thank you so much for joining us in the midst of your busy schedule. It really means a lot, and it was a very wonderful, amazing, insightful, informative session by you. And I have to give you a whole day, but I have given you 1 hour. So sorry for this. Because within that 1 hour maximum you have covered, and maximum you have given an outlook and then the framework about the moot court competitions. And it was really a wonderful session. And we are also doing the YouTube live, because even after some days, many students, anytime they can access to my YouTube channel, Castro Speaks, and they can watch this national webinar on acing the moot court competitions, and they can get an idea and they can take part in the moot court competitions and get into the exposure. The main aim of launching this foundation and organizing these kind of programs, webinars, conferences, and competitions in pan-India level is to encourage the students through education. Because myself and my foundation, we strongly believe education is the only weapon, the only powerful tool which can transform an individual and which can transform the world as a whole. So that's the reason we are focusing on these kind of programs. And even in the upcoming days, many competitions, many webinars, and many programs, and even various other events will be organized to empower the young students in the legal fraternity and non-legal fraternity through various competitions and programs, through education and extracurricular activities and various other events. So I thank Ms. Gopika Nambiar ma'am, Advocate High Court of Madras, for joining us. And in the midst of her busy schedule, she has joined us today. Thank you so much, ma'am. And you are a proud soilmate and a proud alumni to Tamil Nadu Dr. Ambedkar Law University. And we juniors are always proud of you, and we always take you as a great inspiration in all our ways. And best wishes for all your future endeavors. I want to see in the future, not as Ms. Gopika Nambiar, Advocate High Court of Madras, as Honorable Justice Ms. Gopika Nambiar.
Let's see.
So
I'm
best
very young.
wishes
Let's
to
see.
you. You can.
Thank you.
You have all the capability, you have all the hidden talents and caliber and potential power to achieve such levels, and all the best for all your future endeavors. Today, I am declaring this I am declaring you as Honorable Justice today.
Ayo. No. Please don't do that.
Thank you so much. This will happen in the future. Best wishes for all your future endeavors, ma'am. Thank you so much for joining. Thank you so much. I thank digital partner AJ Unlimited, Ajay, and then Rupa ma'am, and everybody all the participants for your wonderful support and taking part in this event, and the YouTube live stream viewers and everybody for joining us today. Thank you, ma'am. Thank you so much. Thank you all.